Greetings, I'm Bruce Alton Carlson. Let's discuss the Second Amendment to the U.S. Constitution. The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to bear and keep arms shall not be infringed." It was ratified in 1791 when Americans had just won independence from Britain. Many feared that a powerful federal army could become a tool of oppression, so militias made up of armed citizens were seen as an essential for freedom. There were two major perspectives. The Federalists supported a strong central government and a standing army. The Anti-Federalists feared tyranny and wanted to protect the ability of citizens to resist through militias. The result was a compromise that acknowledged the importance of both individual self-defense and collective military readiness. Originally, the Bill of Rights, including the Second Amendment, only applied to the federal government. States could and did pass their own gun laws with little federal interference. This changed with the 14th Amendment, ratified after the Civil War in 1868. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens, nor deny any person the equal protection of the laws." The Due Process Clause of the 14th Amendment became the legal foundation for incorporating most of the Bill of Rights, meaning applying them to state governments. For a long time, it was unclear whether the Second Amendment was included. Courts often interpreted the Second Amendment in the context of militia service, not as a personal right to own guns. In United States v. Miller in 1939, the court upheld a federal law banning sawed-off shotguns, saying there was no evidence such a weapon was useful in a militia. The militia context changed in McDonald v. City of Chicago in 2010. When the Supreme Court ruled that the right to bear arms is fundamental and thus incorporated against the states. This meant state and local governments must also respect individual gun rights. Before McDonald, the key turning point was District of Columbia v. Heller. In a 5-4 decision, the court ruled that the Second Amendment protects an individual right to possess firearms, especially for self-defense at home, unrelated to militia service. Then in McDonald, the court used the 14th Amendment to apply this ruling to all states. The majority opinion emphasized that the right to keep and bear arms is deeply rooted in this nation's history and tradition. Together, these two cases transformed the Second Amendment from a federal militia-focused right into a broad, personal right nationwide. The Second Amendment continues to evolve. In New York State Rifle and Pistol Association v. Bruin in 2022, the Supreme Court struck down a New York law requiring people to show proper cause to carry a concealed weapon. The court ruled that modern gun laws must be consistent with the historical tradition of firearm regulation, a standard that makes it harder for governments to justify restrictions. Now, courts must ask, was there a similar law in 1791 or 1868? If not, the regulation may be unconstitutional. This historical test has already led to challenges to laws like assault weapon bans, red flag laws, and background checks. In summary, the Second Amendment's meaning has shifted dramatically from a focus on militias to a broad individual right, thanks in large part to the 14th Amendment. As debates over gun rights and public safety continue, the Second Amendment remains both powerful and polarizing. If you'd like to learn more about the Constitution, please ask questions in the comments, like and subscribe. I hope to see you back here real soon.